Welcome to the program. My name is Marty Shenkman, and I'm joined by Evan Unzelman from a group called CRT Experts. Evan and I have done several CRT webinars in the past. I can't remember on what, but maybe Evan does, and he'll tell you. We're going to talk, and really Evan's going to talk. I'm just here for the ride, about some interesting CRT aspects. There's a number of CRT programs that I've done that are on the website. We're going to be transitioning from Shenkman Law and moving all the educational materials to a new website called Shenkman Education, and we'll announce when that's launched just to make it better and put everything in one place. And those programs that I did with Evan in the past will be there. And there's a number of other CRT programs. I like doing CRT programs with different people at different times because there's just so many fascinating applications of CRTs, and different advisors take different views of it. So hopefully you'll find them all helpful from different lenses. Evan, why don't you just tell everyone who you are, and if you can remember what we actually did in the past webinars on CRTs.
Yeah, so I
Everybody.
remember, gosh, it was probably at least.
I think it was during COVID.
Oh, yeah, that could have been right. Yeah, I think it was, well, it doesn't matter, but I remember one of the programs we did, because you're right, we've done multiple, it was a two-parter, and it was sort of ABCs of CRTs in the first part, and just, situations when you're setting them up and generally how they work. And then we did an advanced in the second part, where we did a deep dive on the technical aspects, net income with makeup, CRTs, and secondary planning, what we'll talk about today. So I do remember that. I remember the two-part series we did.
Do you think it's a fair statement that even though some years have gone by, those are still reasonably
Yeah,
current, that people can watch if they want the background? So if you want a
for sure.
general background on CRTs, if you just search CRT in the Shenkman Law website, and when Shenkman Education is launched there as well, you'll see everything. So let's just jump in and get started, Evan, and I'll advance the slides as you tell me to, and
Okay.
I'll periodically ask you questions just to show, if I can help add any commentary. So go for it.
Sounds good. Yeah, so it's a really interesting time right now with CRT planning. We're seeing lots of activity, which is great. But what's interesting about it, I guess at least for a CRT nerd like me, is that the planning is coming at two completely different ends of the CRT life cycle. On one hand, we're working a lot with structuring CRTs as stretch IRA substitutes. So we're typically creating a CRT through a revocable trust or a will to restore the stretch that the Secure Act eliminated. And these CRTs in most cases aren't going to be around for many or more years because the IRA owner is still alive. And on the other hand, we're working with advisors to fix CRT misalignments that commonly arise pretty deep into the life cycle of a CRT. So trusts that were put in place a long time ago. So, in 2025, a typical day in the morning, I may be working on a sale or rollover of a CRT income interest for a trust that was established in 1998. And then in the afternoon, I'm working on designing a CRT as a stretch IRA substitute for a CRT that probably won't be implemented or be effective until 2040. So it's interesting.
And who knows how many times the law is going to change before then.
Yeah, exactly.
Let me just,
Yeah, go ahead.
Just interject a comment. I think there's a critical point for advisors in both of the things you've just talked about. If you're setting up a CRT to be the receptacle for an IRA to mimic a stretch, no one can predict how many times the tax laws are going to change between now and when that thing's activated. That means that clients need to actually talk to their advisors periodically about, hey, has anything really changed significantly since we set the plan up? The misalignment, and correct me if you feel otherwise, but I think one of the problems why CRTs become significantly misaligned is when they start to go off the path, people aren't really evaluating or looking at them until they're far enough off the path that, oh, gee, we got a problem. So CRTs need to be cared for and fed at least periodically. I don't know what the magic number is, every 2 years, 3 years, 5 years, but every now and then the advisors need to get the clients back to look at them. And if the clients aren't talking to their estate planning attorney often enough, and many don't, the financial advisors really need to step up to the plate and ask these questions about what Evan's talking about. Because if you can catch this stuff early, like before someone dies and has a plan for their IRA into a CRT that's no longer really what they want, you can fix it easily. And ditto, if a plan starts to get off the CRT plan starts to get off the path of what was intended, fix it earlier. So I think it's a huge role, primarily, I think, for financial advisors to blow the whistle and get clients to readdress this. Sorry about that.
Completely agree. Proactive, not reactive.
Yeah.
That's right. Okay, so I know we all know what CRTs are, and if you want, go back to the, like Marty said, go to the site, search up CRT, and you can get a deep dive in advance as you want. But just generally, CRTs. Now we'll talk about CRTs in the IRA, stretch IRA context. But generally speaking, CRTs are tax planning vehicles. They're put in place to defer the tax on the sale of a usually highly appreciated asset. So there's about 85,000 CRTs out there today, and we'll talk about how we know that. But most of those were put in place when a client owned appreciated property, wanted to sell and diversify that asset, didn't want to pay the tax, so we can donate that to the CRT. The CRT is irrevocable, and we give up ownership of the property, liquidity of the property, but the CRT is exempt under Section 664. And so the CRT can sell the property, no taxes owed, just drops into the capital gain tier. And then what the client owns, the donor, is the right to receive income from the trust. Most CRTs are structured as lifetime trusts, so they'll pay out for as long as, often a husband and wife, for their joint lives, as long as one of them is living. And then they'll pay out to charity. Some CRTs are term trusts. We can set up a CRT for a term. We can also set up, we'll talk about this later, we can set up a CRT as what's called a life plus term. But most are lifetime trusts. They're tied to people's lifetimes. And because of that, there's often this natural misalignment that can occur deeper in the life of the CRT. Next slide, Marty. So none of this is an anti-CRT discussion. CRTs are put in place for good reasons. They work well, but because there's this combination of an irrevocable trust, the trust can't change, and a really long duration. I mean, most CRTs are going to go 30, 40 plus years. The CRT can't flex along with changes in the client's life or their goals or circumstances, and it can't change and adapt with the tax environment and the political or the political economic environment. So what we found is, and Marty, you mentioned, sort of at least every 2 years, 4 years. So we've looked at, the team here, almost 10,000 CRTs over the last, well, for me, almost 25 years now working with CRTs. And we've gone back a few times and looked at, when do these misalignments start to occur? And generally speaking, that 10-year mark is sort of a critical milepost for advisors, that when we've looked back, generally 10 to 15 years is when the misalignments start to occur. And of course, they're going to occur at the misalignment rate is going to accelerate over time. The further we are, the more we're removed from when we set up that CRT, the higher the likelihood is that there's going to be some misalignment. But 10 to 15 years in is typically when we start to see the misalignments, and then we'll see them at an increasing rate moving forward.
Evan, can you just, I know you're going to get into it in more detail, but just give a quick example of a misalignment so people understand what you're getting at.
Sure. So, you know what? So we have this life cycle that, and a couple slides here.
All right, so I just want to make sure everyone knows you're going to explain.
Yeah. Fast forward.
Misalignment means.
It might actually be the next slide, Marty.
Is this, you take your CRT to a CRT chiropractor to realign?
Unfortunately, you can't, because you can't change the CRT. Yes. Okay. So here's a perfect example. So a typical CRT life cycle. And if for everyone watching, if you have clients with CRTs, inherit them, you've set them up, this will probably look familiar to you. So we wrote an article or helped write an article for Kiplinger a few years ago, and we created this. This is based on some clients who end up selling their income interest. But and on the next slide, there's a quote from Bill. It's Bill and Sandy are the client names. But on the next slide, you'll see the quote, which really encapsulates what we hear from a lot of these beneficiaries who have CRTs that are older. But Bill and Sandy, typical scenario. So they're in their 50s, appreciated stock, want to sell it, don't want to pay, want to defer the capital gain, teenage kids, big house, expensive lifestyle, private school, travel, etc. So they're looking for income. So the CRT was a great solution. It deferred that capital gain, and then they drew an income stream. Fast forward 10 years, so now they're into their 60s or they're entering retirement, still enjoying that income. The kids are at college, they're paying college tuition. The CRT, the administrative burden starts to become a bit of a burden at this point, and that's one of the things that will happen is we call it simplification. One of the things we hear from a lot of beneficiaries deeper into the life cycles of the trust is, I'm trying to simplify my financial affairs. I wasn't trying to do that when I was set up the CRT. I was looking for income, and now I'm at this point in my life. We fast forward for Bill and Sandy, they're now in their 70s. So we're trying to simplify our financial affairs. We're trying to reduce our taxable income. So, we're 20, 30 years removed from creating that CRT. When we set up the CRT, we're looking for income. We're trying to defer that capital gain. We're 20, 30 years later, we're not focused on ourselves anymore. We're focused on the kids and grandkids. So that's where our planning goals are. We're trying to reduce taxable income. We're not looking for taxable income. And so it's just not the fit that it was when they created it, which makes sense because we're 30 years later. I mean, think about where we were 20 or 30 years ago, just completely
Dark
different
hair.
situations. That's right. So and if you look at and Marty, you hit on this earlier too. If you go to the next slide, you'll see this quote in the article from Bill. So he says that CRT worked so well for so many years, but as I look at it now, it's unlike everything else we owned. Our house worked great, but when the kids moved out, we sold it. Our investment advisors have retooled our portfolio as we've gotten older, and we updated our trust and estate planning as the grandkids were born. We even traded in the suburban for a sedan. But the CRT, which was such a great fit for so many years, can't change like those other things. So Marty, exactly what you mentioned. So for financial advisors, we're constantly retooling portfolios as clients age, enter retirement. The CRT, because it's an irrevocable trust, it's just sort of forgotten about. It's like, well, that's a lifetime lockup. And as we'll talk about here today, that doesn't necessarily have to be the case. There's pretty good flexibility that's available to clients who have these trusts.
It's like life insurance. So many clients buy a life insurance policy and think, oh, it's done. You have to look at stuff. And that's probably the most important lesson of any of this for advisors. Get your clients to speak with whoever on the advisory team can help and who's appropriate, and look at the CRT plan and everything else periodically. And I think what you pointed out, Evan, is really true throughout planning. We all see as clients get older, their appetite for complexity and their goals all evolve.
That's right. And
I'm shocked at this next slide at how old so many CRTs are. And I have to ask you, is this available publicly through IRS data?
Yes,
You have
yeah,
to really
but
dig to find it.
I'll say it's a lot of work because so just to I want to get to this slide. So we go back to Bill and Sandy. That, I've been working. So we call these options, a flexibility that's available to the income interest holder of a CRT, call these secondary planning options. And these have been around since I started working with CRTs in the early 2000s. What we just looked at with Bill and Sandy, that's always been the case. As CRTs get older, these misalignments naturally occur. What's driving this activity is the fact that so many CRTs that are out there today are of the age where these misalignments are occurring. And so how do we know that? Well, the IRS has told us. So in terms of what's available, this isn't, CRT, so this traces back to it was a 2006 Pension Protection Act. And one of the consequences of that act were the portions of the 5227, so the split interest trust tax return, portions of that became publicly available. Well, that didn't mean anything. It wasn't like it was actually publicly available until 2012, 2013. We noticed that some of these websites that track data on charities, GuideStar, Tax Exempt World, Charity Blossom, they started to get the data. And then eventually the IRS started releasing it. And it's been somewhat more consistent over the years in terms of the frequency and what's been released. But it takes a lot of work, because what they're giving you is very macro. And they're giving you, it's split interest trust. It's not just remainder trust. So there's a lot of work. I mean, it's months slogging through Excel, trying to narrow down to, because you're looking at lead trust, there's pooled income funds in there, there's GRATs that are in there. So you're trying to get down to just the charitable remainder trust. Then we can look at high level information, like how many are out there. That's how we know that there's about 85,000 CRTs out there. The geographic distribution of CRTs, so where they are, the size of the CRT marketplace, and more recently they started also releasing when the trusts were formed. And so what that allowed us to do is what you can see here on the screen, and there's actually a pie chart on the next slide that I think makes it's just clearer when you look at it. But when you're looking, what you're seeing here is the age distribution of CRTs.
It's incredible. Incredible.
We break it down into these 5-year increments that you can see. And so you can see that, we're looking at 0 to 4, 5 to 9, 10 to 14, 15 to 19, 20 to 25, 25 plus. So if you look at this in the percentages, over 75%, 3/4 of the outstanding CRTs in the marketplace are more than 15 or more years old. And remember what we talked about earlier. Just click once, Marty. Yeah. So remember what we talked about earlier. That's right where these misalignments start to occur. So 75% of the CRTs out there are at this critical juncture where misalignments are most likely to be present, and these secondary planning techniques that we'll talk about here are going to be relevant. In our experience, when it comes, so I want to talk first about why the flexibility exists, and then we'll talk about what the options are. But in our experience, because the options are, and we'll see this, they're creating such distinct client outcomes. In most cases, the vast majority of cases, one of these secondary planning options that we'll look at can pretty much directly solve the misalignment. They're going to address it head on. It's misaligned because planning goals have shifted to the kids. Okay, we have two options, the sale and the rollover, that can directly address that misalignment. It's just a matter of how do you want to address it. Do you want to address it with cash or a new CRT income stream? So that's the good news, is when these misalignments do exist, we can solve them pretty directly with secondary planning. And so why they exist is, we'll see they create different outcomes, but they're all possible for the same reason, and that is the IRS views the life interest in a trust as a capital asset. So, and clients don't look at their CRT income interest this way, and that's one of the big problems, is that it's, again, lifetime lockup, set it up, forget it, but their income interest in their trust is a private capital asset. It's in many ways no different than a piece of real estate. It's a capital asset that they can sell for cash, that they can give the charity, or they can use to create a new CRT with different terms, a technique that we call CRT rollover. So these are the three options. And what makes this easy is that, and as we wrap up this part of the discussion, I'll put another slide up that kind of drives the same point, is that it's, as long as, to Marty's point, we're proactive about this and we make the clients aware of this is what you can do with your income interest, based on the client's situation and what their goals are, it's pretty obvious which one of these, because they create such distinct outcomes, it's pretty obvious which one of these is going to be appropriate. So let's go to the first one, which is the sale. So the sale is it's probably the easiest, and it's the most commonly utilized by a fairly wide margin. We think the rollovers, there's more to the rollovers, so it's a little more complex, which puts sort of a size threshold on it. But we think we should be doing more of those rollovers than we are. But with the sale, this is what most clients who choose to do something are going to choose to do. So it's just, if I own an income interest in a CRT, that's a capital asset that I can sell. I can sell that to a third party for cash. It's a capital transaction. The sale proceeds, therefore, are going to be a capital gain property to me. I'm going to get a 1099-B next year to report that capital gain on my personal tax return. I've effectively been cashed out of the trust. In addition, I'm going to shift that administrative responsibility over to the buyer. So most CRTs are self-trusteed. The income beneficiary, who's usually the donor, is the income beneficiary, is the trustee. And so one of the things in connection with the sale, I'm going to resign as trustee and appoint as successor trustee the buyer, one of the buyer's advisors. So that's going to shift off the future administrative responsibility for the CRT. The trust itself is not affected. We can't affect the trust. It's a buyer, a third-party buyer is bringing their own assets to cash, to escrow, paying me for the right to step into my shoes as the income beneficiary of the trust. Stays tied to the income stream, stays tied to my lifetime, still pays charity upon my death, but the income stream has been redirected to the third party in exchange for the payment, the cash payment at closing. So,
Evan, without
yeah.
asking in detail, what are the types of people that are these third-party buyers? And is that something you do to find the third-party buyers? I wouldn't know where to find a third-party buyer.
Yeah, sure. So we broker the sale for a fee. So for better or worse, we're like the real estate agent. So we broker the sale of the income interest for a fee that's tied to the sale price. We're paid by the seller at closing. So when we're looking for buyers, we're not picky. We're looking for any buyer that will put the same or more value on the future stream of income than a seller. What we look for, though, beyond the obvious, so high net worth, good liquidity, but we're looking for all the buyers are taxable, whether it's an individual or an entity, but we're looking for taxable individuals, taxable entities, families, groups who are tax advantaged. So if we have, for example, a taxable entity with a net operating loss, and they're willing to use that tax attribute against the income from a CRT, we can match them up with someone who has a CRT, who's paying tax on that income stream, and find a price that makes sense for both sides. So any tax attribute, net operating losses in entities, capital loss carry forwards for individuals, unused charitable deductions. Again, we're not picky, but that tax differential in many cases is what drives the transaction, what gives us the ability to arrange a sale at a price that would make sense for both parties.
The CRTs that are sold, are they all invested in marketable securities?
Not always, no. So that's easiest, because if we have a CRT that's in, we just did one not too long ago that was in, it was in a warehouse in somewhere in the Midwest. So it's a NIM-CRUD, obviously, and we found a buyer. It was not easy. So you have to find a buyer that's comfortable purchasing that income interest. So in most cases, CRTs are in marketable assets. So that's not an issue. But if we have illiquid assets, that doesn't preclude the sale. It just makes it harder for us as the broker of the sale to find a buyer. In some cases, we can't. It just depends on the.
I didn't even think it would be possible. So that's interesting.
Yep. So that's the sale. So in terms of the benefits, again, I mentioned it earlier, simplification. We just hear this all the time. I'm just trying, Bill and Sandy, 20, 25 years later, just trying to simplify their financial affairs. Obviously, this is providing liquidity. A lot of people like the flexibility of cash. I could sit here until tomorrow and talk about the reasons we've heard from sellers as far as why they want that cash instead of that future income stream. In a lot of cases, it comes down to kids. So we always joke, if the kids got to make the decision, we would do a lot more transactions, because if my parents have a CRT, there's no direct benefit to me. They take the income, they die, everything goes to charity. If they sell, they're retaking control of those assets. If I'm part of their planning and they don't spend all the sale proceeds, then some of that may come to me. So in a lot of cases, this is the driver is heirs. But if we're looking, so if you go to one more slide, Marty, this will bridge us to the rollover. So the rollover, it's a different fact pattern. So this is a client, but heirs in many cases are the driver. So the way to think about a rollover is if someone has a CRT and they're still a good fit for a CRT, just different than the one that they have now. So in many cases, what that means is I would rather have different income beneficiaries on the CRT. My kids, sometimes we have a spouse that wasn't, either I wasn't married, we weren't married then, and now I have a spouse that is not an income beneficiary of the CRT. And so if we could, what would we do? We would just add them as an income beneficiary. Obviously, we can't do that. So, but what we can do is use our income interest in the trust, our existing trust, to fund and monetize a new CRT. So the scenario that is most common here is client has a CRT, they don't need the income that is, in a lot of cases, they don't want that taxable income. They're not a candidate for the sale, so they're not looking for cash, they don't want the capital gain. They have kids and they're still interested in doing planning for the kids. On paper, that's a really good fit for a rollover. So what they can do is, with their attorney, they'll create a new CRT. So blank canvas, we create a brand new CRT, reflective of whatever terms are in line with their situation today. So in many cases, it's putting their kids, grandkids on as the income beneficiaries of that new CRT. Then they'll irrevocably contribute their existing income interest to that new CRT. The new CRT will sell it. So there's still a sale, but the seller is that new CRT. So if I can sell my income interest in my CRT for $1 million, that's the sale option. I get $1 million in my pocket or my brokerage account, and I pay tax on that capital gain. With the rollover, I'm creating a new CRT, contributing my income interest to the new CRT, and that's selling it for $1 million. The buyer doesn't care who they're buying it from. So now we've got $1 million in the new CRT, and that will pay heirs, or in some cases it's still me. We're moving maybe from a standard CRT to a NIM CRT for deferral or something like that. So it's in effect a way to make changes to a CRT. We're not actually making changes to the CRT. We can't do that. The closest we can get to like we can't decant the CRT, obviously, but the closest we can get, I can't change the trust, but I can use my income interest in it. That's what I own. That's a capital asset, and I'm using that to fund and monetize a new CRT that has different terms.
It's a great idea for the right clients.
Mm-hmm. So let's kind of go through the client fact pattern again to get to this last option. So client doesn't need the cash. They're not looking for the cash. They not a fit for the rollover, which typically means they don't have kids, or they're just not interested in doing more planning for their kids. And so now we're to this final option, which is they can give their income interest to charity. So we're asked a lot on this. Well, so if I give my income interest to charity, does that qualify for a tax deduction? How is that not double dipping? I already got a tax deduction for the CRT. And then two, do I need to file the 8283, the form 8283 for the non-marketable asset? So the answer to both of those is yes. So let's think about why. So when you set up a CRT, you get a deduction for the IRS value of the remainder interest of what the IRS projects to go to charity. We're not giving that away here. 20 years later, if I give my income interest to charity, I'm giving the other interest, the non-charitable interest, to charity. And so that's why it's not double dipping. I'm just taking a deduction now for my interest, the non-charitable interest. The answer to the second question, yes, you need to get a qualify. You're going to need to file a form 8283 for the non-marketable asset with your tax return, your personal return to claim the deduction. And we're asked a lot, well, why? The CRT's in all marketable, or it's all in cash. Well, you're not giving the CRT away. You're giving your income interest. Exactly.
Yeah.
And your income interest is a non-marketable asset. And so it's not an expensive endeavor. Just find a qualified appraiser who has software. And it will go through a quick example here, and we show the output from our software. I mean, I wish we're not qualified appraisers, so we can't sign it. I wish I could, because I could give that to you in 5 minutes, just pull it up in the software. So it's not an expensive endeavor, but it is, you do need to file that 8283 in connection with claiming that deduction.
Couple of quick comments. Where I've seen this particular exit strategy, if that's the right word, or correction of misalignment, using your terminology, done, clients, when they did it, they had a business that they were selling, they did a charitable bailout, they had a highly appreciated property, they wanted the income tax benefit. Roll forward decades later, their investment portfolio's grown, they realize they don't need the money, they're happy to help a charitable cause that they were interested in before, and this is just a great option. I don't know if it helps, but I could see how, when Evan pointed out, I never thought about it, but gee, I got a deduction before, how am I getting a deduction now? Theoretically, and I don't think it actually lines up, but theoretically, if you added what you got before and what you get on the value of the income interest, that should be the value of the asset, theoretically. I mean, it's probably never going to work out that way, but you got the back end up front, as Evan said, and then you're now getting the value of the retained income interest.
Depends on if that trust has grown or not over the years, right?
Just theoretically. So you're not getting more than a whole. It just changes in value and stuff like that. Be very careful when you have to file and report to the IRS. Every year there's more cases where people lose a charitable contribution deduction because they just didn't go to follow the rules in detail. Make sure you get the qualified appraisal. Make sure I would even do it yourself, even if you have a CPA, which you should do doing the filing. Read the instructions to the form. Just make sure all those little I's are dotted and T's crossed, because the IRS has been tough where slight variations from what's required, people have lost deductions. You certainly don't want to do that.
So what I want to do here is, let's go back to Bill and Sandy. Remember them from the CRT life cycle. Let's attach numbers to these options. Let's run through the option and just attach numbers to place that in context for everyone as we wrap up this portion of the program. So Bill and Sandy here, they're 78 and 73, $1.2 million in assets in the CRT, 7% payout rate. So the first thing that we're going to do when we're reviewing a CRT is we're going to establish a valuation range for their income interest. We're going to run a present value calculation, which, Marty, if you flip to the next slide, you'll see we've got a 7% payout. We'll just assume that the trust earns that 7% net of any fees. So we have a level $84,000 per year in distributions. We looked at 3 life expectancy tables here. So what that allows us to do is put a valuation range on the income interest. So depending on which table we're using, this is going to range from $793,500 to $910,000. So the way to look at this is the right to receive $84,000 a year over the remaining lifetimes of a 78 and 73-year-old is worth between $794,000 and $910,000 on a present value basis in today's dollars. So that gives us what's usually, if we're looking at comparing to the sale, is usually the most appropriate or relevant benchmark. Typically, as we saw here, the income interest should be saleable at sometimes a little bit above the top end of that range. But we also have an IRS benchmark, which you'll see here on the next slide, Marty. So this is what we would have to use if Bill and Sandy were donating their income interest to charity. So we have to plug in, you can see we've plugged in the trust value, their ages, payout rate. In this software, we use Crescendo. So this is giving us two values. Down there in the bottom circled, that's the remainder, the IRS value of the remainder interest. So if they set up a CRT today with identical terms, that would be their tax deduction. What the other value that we're looking for, which is up at the top highlighted and circled, that's the IRS value of their income interest. So that's what the appraiser is going to use. You can use, easy charitable, tiger tables, number cruncher. It's all going to come to the exact same figure. They're going to plug in the facts, and that's the value of the income interest. If Bill and Sandy gave their income interest to charity, that is what they would receive in terms of the charitable deduction. And it does give us another benchmark if you flip to the next slide to compare to the sale price. And this is pretty representative when it comes to the sale of the income interest, how that will stack up against the present value range and that government value, the IRS value. So I compare this a lot to real estate, another private capital asset. The government, there's an assessed value of my home for purposes of taxation. If I go list and sell my house in the real world, in most cases, the real value of the property is more than what the government has assessed that value at. And that's the case here. Typically, if the income interest will be saleable right around the top end of that valuation range. Okay, so you're going to click once. Okay, so we're just going to go sale, rollover, gift. So we're going to see the different options these create. Not in the sale option, Bill and Sandy, that's $935,000 to them personally. That's capital gain, it's capital transaction. They can do whatever they want with that money. It's the flexibility of that cash. With the rollover option, that $935,000 is going into a new CRT, usually for heirs. So it's creating income for heirs. With the deduction, or with the gift out, we're getting a $768,000 deduction, the IRS value of the income interest, which for a top bracket payer is probably $350,000 in cash value tax savings. So very different outcomes. So that's why if you go to the next slide here, Marty, that's why what I said earlier, as long as we sit down with the client and make the client aware, it's not a complicated in terms of the decision. We just match up the outcome that the client's looking to achieve with the appropriate option. They're looking at maximum value to me. We're going to end up with the sale, heirs with the rollover, and charity with the gift option. So now we're going to go from it's fascinating. So we're going to go from looking at CRTs that are pretty deep into their life cycle. We're going to go to the complete opposite end of the life cycle. Well, we're going to go further than that. I guess the opposite end would be CRT inception. We're going to go before inception when we're talking about, yeah, that's right. We're going back all the way back to CRTs as stretch IRA substitutes. So let's talk about that. Oh, there we go. Okay. So yeah, flip to the next slide, Marty. So we all know the problem here is that the Secure Act effectively ended the stretch IRA. So instead of beneficiaries being able to withdraw income over their remaining lifetimes, they must withdraw it within 10 years. And of course, those distributions are going to be taxed at the highest applicable rate. So for the client that was looking to use the IRA stretch, that creates a problem. Whether you want to call it a tax disaster, and it's effectively a large tax on the IRA after the death of the IRA owner, however you want to describe it, for the clients who had planned on their IRAs distributing over their remaining lifetime, or the lifetimes of their children, this creates a problem. Fortunately, with a CRT, we have a pretty natural solution.
Let me just interject a
Yeah.
comment. I'm concerned that there's a lot of clients out there that set up plans based on the stretch, getting long years to pull out that IRA over, let's say, the kids' lives or something like that. And they haven't really, it hasn't registered to them, gee, all that's changed. I got to redo the planning. So I think one of the most important things for advisors, and again, the financial advisors may be seeing these clients quarterly, and they may not be going back to their estate planners as often as they really should. Catch this if there's a plan with a big, if there's a client with a big IRA retirement plan and they were doing something with the stretch, have they revised their beneficiary designations? Have they reevaluated their planning? What Evan's got is a very clever solution, and it's something certainly worth looking at, but that's not going to happen if they haven't even approached the question. So get them to look at it, because I just fear there's a lot of people out there that just have, it's like, it's done. I don't have to deal with it. I don't want to deal with thinking about dying. It's done, and they need to.
Yeah. As the late Steve Jobs once said, how can someone want what they don't know exists? And it's that you got to make them aware of it.
Yeah.
So when we think about an IRA, at the core of it is tax efficiency. That's what's driving the value of the IRA. We are investing pre-tax dollars in a tax-free account. And even though the Secure Act ended the stretch IRA so that it can't be stretched beyond the 10 years anymore, we can replace it with the CRT. So the CRT is an exempt trust, as we know, just like an IRA. So on the IRA owner's death, if the CRT is named the beneficiary, all of the IRA assets can go into the CRT with no income tax. Like the IRA, the CRT is able to grow those assets tax-free. So the investment advisor has the benefit of no tax drag on the investments moving forward, as long as they're in the exempt trust. Also, like an IRA, the distributions to the CRT beneficiary are taxable. Unlike an IRA, though, the CRT is eventually able to distribute capital gain. Now we have to, the way that the income from a CRT is taxed, it's taxed through a 4-tier accounting structure. Ordinary has to come out first. So in these IRA situations, you've got a large slug of ordinary income that has to be distributed out first. So we model these all the time. It's usually like, as long as they're taking distributions and not deferring, it's like 15 years in, we can get through that ordinary income. As long as that trust has been invested for capital appreciation, which most likely it would be, we can now get into the capital gain tier and start taking the income, the kids, at capital gains rates. And so we actually have some tax advantages down the road with the CRT, even when compared to the old stretch IRA, which obviously isn't possible anymore.
The acronym for what Evan was talking about is WIFO, WIFO, worst in, first out. So you have to pull out of the CRT the most costly taxed income before you get to the better stuff. Worst in, first out.
That's right.
Evan, what about creating a structure? Let's say the client's not sure what they want to do and they're leaving an IRA to 2 kids 50-50. Can they leave it to John and Jane and then provide that if John or Jane should disclaim, the first disclaimer would put it into a CRT for them, and then if that's disclaimed, it could just go to their kids, just to build.
I think so, right? Yeah, as long as the trust terms would have to be they would have to be inside of the planning.
Right.
But I think so.
Yeah, I want to think about that more, because that may be a nice way to give flexibility without too much.
So it's pretty well known. We see the PLRs up there. There were in the 90s, there were several PLRs that confirmed that a qualified trust like a CRT can be the beneficiary of a qualified plan. And of course, we know once the assets are in the CRT is exempt under 664. So you can see it up there. This is that's pretty well known. So what we've been able to do here is restore the stretch. The CRT is preserving the pre-tax dollars in a tax-free account. The trust is growing tax-free under Section 664, and the heirs are getting significantly more money. We'll look at an example here in a bit to see how much more, at least with this example. I will say though, I mean, this isn't, we wish that this was just purely made through an after-tax value lens, like what's maximizing overall family wealth. CRT is going to win that one every time. I mean, the clients who are, and obviously we know these, they exist. You know, there are clients out there that are just okay with the kids getting the money quickly, in many cases just all in year one, regardless of the tax consequences. You know, we can model and model and model and model and demonstrate that, well, you can stretch it over their lifetime. Look how much more. It's not going to change their mind. Where this makes sense, and this gets to what Marty, you were saying, is it's for the clients who had anticipated using the stretch IRA, and those clients, this is just such a natural solution.
A lot of clients like the idea that the kids can't blow it if they do something foolish initially. So
a creative spender, yeah.
Yeah, it's an easy sell from that perspective, because hey, your kid's going to get the money over X number of years or lifetime or something like that is a lot. Clients like that. When you talk about asset protection from creditors, though, I'm sorry, I didn't mean to do that. Isn't there the issue that the payments out of the CRT each year are reachable? So I guess you're preserving the principal inside the trust, which is a huge improvement over just getting the money.
Yeah, so you could put a spendthrift in it, and a spendthrift so this is not a self-settled trust. So if we're dealing with someone that is the donor and the income beneficiary, you put a spendthrift in it, but you can't spendthrift yourself. Here, you could put a spendthrift in, it's not self-settled, so right. I think the spendthrift would potentially hold up more. But yes, you've got the principal that's inside of the tax-exempt trust.
It's only the annual payment that could be reachable, but you've at least preserved
right.
the principal for many years. So that's a good thing.
That is a good thing. Okay, so we've kind of gone through this in terms of just the who are not the candidates, the client that, now we'll talk about just financial threshold, but the client who's just, they're okay with their kids getting the money right away, regardless of the tax cost, they're not going to be a candidate for this. Who is a candidate is the clients that, again, we're probably already anticipating using the IRA stretch when that was available. Now, a disadvantage of the CRT compared to the old IRA stretch is the CRT is its own entity that does require trust administration. So there is an administrative cost here, and that really puts a threshold on where this would make sense. And this is the same as if someone has appreciated property and they're just thinking about setting up a CRT for themselves. If they've got $100,000 in appreciated property, that's okay. You're probably going to pay $1,000, $2,000 a year just for the administration. That starts to eat into that trust value, because the trust still has to pay out the distribution. So we'll generally say 500,000 and up in expected IRA assets. You can go lower. It's just, where's your tolerance for those administrative costs relative to the trust value? And obviously we're thinking about this as we get older. So 50 and up, 500,000 and up in expected IRA assets, interested in maximizing after-tax value dollars for the heirs. That's a good candidate for using the CRT here. So we'll talk about implementation, but just two things up front. You can't wait. You have to, and this is actually helpful when we think about, certainly charitable planning, but any type of planning. One of the biggest hurdles is always inertia on the part of the client to pull the trigger on the planning. Well, you can't push this one off, because you have to do it. The IRA owner has to do it during their lifetime. And if the decision is made to do this, even if it's through a revocable trust, like we'll talk about, which is usually what we would recommend, CRT design matters. We need to think about the CRT design, what the client's looking to do, in this case for their kids, and in many cases grandkids, and make sure that we're incorporating all of the flexibility that's available under 664.
The biggest problem that I see in practice with most clients is getting them, exactly as Evan said, to pull the trigger. And I think one of the best ways to get clients to the finish line is involve all their advisors. The more people they hear the same message from, yeah, get it done, do it, the more likely they are to get to the point. A lot of clients really struggle pulling the trigger where they're going to feel that, you know, they're dealing with issues of facing their own demise. It's just not easy. So again, involve all the advisors, get everybody helping encourage the client. You know, if they've all agreed to the plan, why not?
Okay, so implementation. So there's three general ways to do it. One of which is by far the most common, at least in our experience. But the end result's always the same. We're going to go to the custodian of the IRA, and we're going to do a change of beneficiary, and we're going to name the trust as, or the trustee of the trust as the beneficiary of the IRA. So that's how things are implemented after the trust, whether it's revocable or done on an irrevocable or revocable basis, is drafted. So we'll talk about funded first, then unfunded, then testamentary. So we can do this with a funded CRT, which can be an existing CRT. So as long as the CRT in the trust agreement, in the trust instrument, we have the language permitting additional contributions and addressing how those are dealt with, we can name the existing CRT, the funded CRT, as the beneficiary of the IRA. So where would we see this? If we have husband and wife, husband has a CRT, or they're both beneficiaries of a CRT, husband has an IRA, older, expected to pass first, can name the CRT as a beneficiary of the IRA. Now you lose the kids unless you already have the kids as beneficiaries of CRT, but a funded CRT will work in this context. An unfunded CRT, you can do this, again, not common, but you can, so we can create a CRT, fund it nominally, and that's going to be it's going to qualify under state statutes, but under the federal statutes, there's not a requirement for administration. So if we have a nominally funded CRT, we couldn't afford to administer it. So, but we don't have to. But it is irrevocable in that context. So to maintain the flexibility here, what we would generally recommend and what we typically will see is this done through a revocable trust or will. So what that gives us the ability to do is we can put everything in place now based on the IRA owner's current wishes, and so they're going to have, obviously there is some upfront cost there, but then it's in place. There's no ongoing costs until they die and everything goes into place, but it's revocable. So if they want to make changes to it, if grandkids are born, they want to add beneficiaries, maybe they want to subtract the beneficiary, they want to undo it. It's Marty, as you said, if the laws change. So it gives us that flexibility, doing it on a revocable basis through a revocable trust or a will.
And if you set it up, your CRT inside a revocable trust, you then take the beneficiary designation on the existing, say, IRA, and name that CRT that's formed under the revocable trust.
Correct.
Mm-hmm. So one of the things that I like doing with clients is if you build something, if you build something like this into revocable trust, I like the idea of being able to change things because the world is so uncertain. But in addition to that, if you put the mechanism, the trust, the CRT subtrust, if you will, inside the client's revocable trust, you can give them the beneficiary designation and say, listen, if you want to use this planning technique, you can just change the beneficiary. If you change the beneficiary and you decide you don't want to do that, just change the beneficiary designation. So it's very flexible.
Yep.
Should we
Next
go
slide,
on?
Marty. Yeah, sorry. Okay. So we'll go through the numbers here. Again, it's spoiler alert, the family with the CRT that uses CRT is gonna come out ahead here. But I do want to just run through an example because they will also give us the ability to look at, we can see the numbers, but we can also look at some of the design features that we will often include here. So we have two families, A and B. B uses the CRT, everything's the same. They're taking $1 million IRA, everything's the same except family B uses the CRT. So they're going to take that IRA through the CRT. Family A is going to do it. They're just going to take it directly from the IRA. So let's look at, before we look at the outcome, let's look at the structure of the CRT here for family B, which you'll see on the next slide. So one thing we're asked a lot is, well, what if we have, because when we're creating CRTs and we're talking about trying to add heirs, we're always up against what's called the 10% remainder test, which is an actuarial, it's what it is the IRS, we saw the calculations earlier. The IRS will look at what's the value of the income interest, what's the value of the remainder interest, and they're going to base that on their own interest rate, their own life expectancies, the payout rate of the trust. And so at least 10% of what goes into the trust, that needs to be, the remainder value has to be at least 10%. And that limits us in terms of how many income beneficiaries we can add, the payout rate of the trust. So if we have, in this case, we have two kids, and this is actually two different CRTs. We're just, it's conceptually, it's easier just to look at it as one. But if we have 4 kids, if we have more beneficiaries, younger beneficiaries, we can still accomplish this. We just have to use multiple CRTs. As long as we're using the same administrator, that should not be more, I mean, it shouldn't be more expensive as long as we're using the same administrator. If we use different CRTs, that's what will allow us. In this case, we can see we can put the grandkids on. We're tacking on an entire another generation here by using the multiple CRTs. So whether we're using 1 CRT or 10 CRTs, it's all the same. The IRA assets go into the CRT. There's no income tax owed. In this case, we're going to put the spouse on as the income beneficiary, the initial income beneficiary. And we'll look at a twist on this as we wrap up, where the spouse can defer income, and we'll see that impact. But the spouse is the initial income beneficiary. When the spouse passes, it will go to the kids, the 2 children, for their lifetimes. And then as they pass, it will go to the grandkids for a term of years. So this is what's called a life plus term structure. One of the often overlooked or one of the planning, one of the design features within 664 that's not utilized enough is this life. A lot of times it's, well, CRT's only, I can set up for lifetime or term of maximum of 20 years. No, it's not. So you can set up a CRT for lifetimes plus the shorter of a fixed term or additional people's lifetimes. So what we can do here, as long as everyone's living and known at the time that the trust is effective, we can set up a CRT that will run for, in this case, multiple lifetimes plus a term of years to the grandkids. From a life expectancy standpoint, it's always going to end up being that term. The grandkids are always going to well outlive that term of years. But what that allows us to do is, at least for a fixed term of years, include a whole nother generation here. And so what we'll do with our planning typically is we'll just put it in, we'll put it at 5% as a payout rate. So that's the minimum. So that's going to allow us the longest successor term to those grandkids. We'll start at 20 and just start pulling it back until we pass the 10% test. And so in many cases, we're going to get 10 to 20 years of income to that third generation. And if that trust is, especially if that trust is put into deferral, that's a meaningful amount. So and I'll talk about this on another slide, but we always want, generally speaking, we want to include as many family members as we can, and we want that CRT to last as long as possible. And that should be, right now with the 75-20 rates where they are, I mean, when we set up a CRT, we want to see 55, 60 years on that duration. And typically we can, as long as we're structuring it properly. Okay, so here, I mean, typically I would show these graph by graph and then show the overlay, but we got to try to keep on schedule. So we'll just look at this one here. So what we see here is, so the solid green line is the value of the CRT account. That's the investment account. So it's distributing 5% each year. That $1 million goes into it, no tax owed. We've assumed 7% growth on both options. So it's distributing 5% and it's growing at 7%. The solid red line you see is that's the IRA. So it's distributing all the assets over that 10-year period. And then that dotted red line shows the value of the money withdrawn from the IRA after taxes and spending that's reinvested. So to keep it apples to apples, we assume that the heirs spend the exact same amount in each scenario. So the vertical green lines, that's the distribution from the CRT. And then the red vertical lines, that's the same amount that is withdrawn from the reinvested IRA withdrawals. And as you can see, eventually the money runs out from the IRA, but the CRT keeps on going. You know, the immediate tax hit, and that's why it's not a fair comparison. That immediate tax hit on the IRA is just too much for that strategy to overcome when it's put up against a CRT that's maintaining the assets in that tax-free environment. So you can see here, $1.6 million versus almost 3.6 million. It's more than double. So CRT design, I don't want to gloss over these, but that's again a topic for another webinar. But so obviously there's two things here. Typically, when we're setting up a CRT in the traditional scenario where someone's setting up a CRT for themselves, we want maximum flexibility. And we're going to look at things like trusteeship, the ability to replace trustees, remove, add trustees. We're going to look at the charitable beneficiary, making sure that they have flexibility to adjust the charitable beneficiary. Anything that's possible under 664 in terms of flexibility, we want to at least give the client the option of including it. It is a little different here because we're creating CRTs for heirs. So in some cases, we may want to take some of that flexibility away with trust. If we're concerned about that creative spender, the CRT is a great solution, right? Because it's just giving them the income stream. We probably wouldn't want them as a trustee to give them the investment control over the investment management. So there are some differences, but generally speaking, when it comes to CRT design, the two features that are just so often not included that should be. When I say that, I mean, if the donor was given the ability to include it, they would have. The first is duration. We talked about that, making sure that we're including as many beneficiaries as possible. We're stretching that duration out as long as possible. And the second is deferral. Deferral means if we're going to need to use what's called a net income with makeup, a NIMCRUT, and we're going to have to, in most cases, we would recommend combining that with a single member LLC, maybe a partnership, a variable annuity. Typically out of these, we would recommend the LLC. And what that, and again, you can go watch webinars on these techniques, but generally speaking, what that will give, especially when you've got that spouse on there as the initial income beneficiary, a lot of cases that spouse won't need the income. So still put the spouse on, but then give the spouse the ability to defer income, because that will allow that trust to grow tax-free for some period. In this case, Marty, if you flip to the next slide, it shows that same comparison, but let's assume that spouse, so same structure, we're just assuming that the spouse defers, and then on the next slide, you'll see that same chart, but you'll see so now, if you look at family B, look how much more income there is because you've put this trust in deferral for 10 years. You allow that investment advisor to grow those assets tax-free with no distributions over 10 years. it's growing those, it's going to basically turbocharges the value of the CRT, and that's of course going to augment the distributions that are available for the family. So another design feature that we want to that we don't want to overlook.
Just for those listening, the concept of using an entity underneath a NIMCRUT is a fascinating and incredibly powerful tool. It's also incredibly complicated. How Evan described it in about 40 seconds, I'm not sure, but there's a lot of detail in that. And I may have actually a webinar on that topic specifically on the website, but if not, we should probably do one. And some people have different views, whether it should be a single member LLC or a multi-member LLC, so it's more likely to be respected, and who can be the manager of the LLC. You get into a lot of nuance, and you have to understand the differences between fiduciary accounting income, FAI, and taxable income. It gets very intense very quick, but the impact of it, as Evan just showed you, is really potentially incredible.
So, you got to do it right, though, and you're exactly right. It gets very complex, and you've got to do it right.
Yeah, as the old saying goes, the devil's in the details. So it's a fascinating idea. I'm glad Evan brought it up, because at least it's on your radar screen. But that's something that really takes some serious digging. But fascinating results. Evan, let me ask you a self-serving question for you. If an advisor has clients where these techniques make sense, how far, I mean, you're not a law firm, so you don't draft documents, I'm guessing, or do you?
No, we cannot. I mean, we can provide a specimen document, but it's got to be, we are not attorneys. We're not the attorneys. So that the client has to have an attorney that we certainly, even if we're not providing that, we like to look over it to make sure that we're including all those design features. But
you can do everything almost turnkey.
Yeah.
Other than the actual drafting the document, and you can provide a sample for that as well.
That's right.
So an advisor that wants to pursue this with a client that doesn't feel they have the background, other than the lawyer drafting the document, not to minimize that role is important, but you can help them with every aspect of this.
Yes.
Okay.
Yep.
I know that sounds like a sales pitch, but I wanted to ask because I think there's a lot of people that are going to be intrigued by this, but not sure what to do next, and they can talk to you.
100%.
I know. Okay, everybody. I want to thank, anything else we got to say?
No, this has been fun. I appreciate the opportunity.
I like the idea, but next time we're going to switch it and do the IRA first, because then the other stuff comes 20 years down the road. But I think it's fascinating the way Evan bookended the discussion on IRA planning, and there's obviously a zillion other things that we could talk about with IRAs, but these are two really interesting applications. And one of the things that they both have in common, it's a phenomenal opportunity for advisors in every discipline to be able to give a huge value add to their clients, because when you can help a client defer income for a lengthy period of time, you see the potential benefits from that. If you can help an IRA client with an IRA that's, I'll use Evan's word, misaligned, but it's just not meeting their goals because life changes over decades and decades of time. That's a home run for the client. You can really help them benefit, whether it's, their kids, themselves, or charity, in a way that they probably didn't even imagine feasible with an irrevocable trust. So great opportunities for value add. I want to thank Evan for really being so clear on introducing and explaining these concepts. The visuals are great, and I hope you all found it informative. Thank you for joining us, and good luck, everybody.